right. Good morning, Trinidad and Tobago.
Morning.
My name is Robert. You are locked on to the Street 919. And we are now going to take you over to Let's Talk Legal. Can you hear me, guys?
Yes, I am. Yes, I am.
Okay, great.
If I get up.
Are you hearing me?
Yes, I can hear you. Just a minute. Yes. All right. Okay.
Okay.
So, are we also online to our YouTube listeners?
Yes, we are live on YouTube. And we are live on Facebook.
Excellent.
All right.
And we're recording as well.
Yes, we are about to record now.
Recording in progress.
Oh,
All right.
All right now.
Good morning to all our listeners. Good morning, Trinidad and Tobago, and the listeners of Street 919 FM. Welcome to Let's Talk Legal. Welcome this morning to another segment and edition of Let's Talk Legal, brought to you here every Monday and Thursday right here on the Street 919 FM, courtesy DL Daniel and Associates Limited, Legal Administrative Consultancy. Thank you so much for having us this morning. I am your host, Ms. Shakila Daniel of DL Daniel and Associates, joined by the wonderful Mrs. Avian Joseph, attorney at law, one of the partners of DS Daniel and Associates. Good morning, Ms. Joseph.
A very good morning to you, and how are you today?
I am fine. I can't complain. We are seeing another day. Thank God.
Yeah.
And so that is indeed a blessing. So many privilege of life. And so this morning, we are going to speak on part 3 of family law. And quite fittingly, we have with us who I like to call a family law expert, Ms. Joseph. Ms. Joseph would have taught me in my UE days, Law and the Family, a very excellent course to which I am eternally grateful. And for that and so many other reasons, I often believe that she's one of the best persons we have locally to really dive in on topics relating to family law and its application in real life. All right? So without further ado, we want to dive right into this topic. We want to remind our listeners that you can call us with any questions, queries, or concerns that you may have in relation to this morning's information after the program. We really beg that you call us after the program. The number to call is 769-6410, 769-6410. It can also be messaged via WhatsApp, but please reserve communications for after the program for us to get back to you. Remember, this is a legal information and education program. We will not be giving legal advice on air. All right, so Ms. Joseph, thanks for being with us. And this morning we're talking about maintenance, and more specifically, child maintenance in family law.
Right, I like that word, child maintenance.
Yes, child maintenance. We know that, and we've often discussed this in the office, that the American law and legal system is often adopted in the minds of many of our population because we are so bombarded by American media, right? As it relates to family law issues. And what I mean by that, we often have clients that come in and ask about divorce on the grounds of
irreconcilable differences.
Yes, irreconcilable differences. And we dealt with that last time in part 1 in divorce and spoke about, the ground in Trinidad and Tobago is different. But we also find an American adoption with the term what is it? Oh boy.
Money payments?
Yes,
money?
Yes, for payments. They talk, instead of saying child maintenance, the American term for it.
I think they say maintenance too, But one of the big challenges, we love the word alimony.
Yes.
I guess it's because it's close to money.
Right.
We like to talk about alimony for when you leave in a marriage. But we dealt with that last week, and as you rightly said, today our focus is on child maintenance. So
the term I'm looking for is child support.
Right.
Child in America support. Is child support, payment of child support, right? Mm-hmm. And I've seen many people Google that locally. But under our law, the term is child maintenance. Am I correct when coming to the court?
Oh, better, we don't even say child maintenance. We say maintenance for children.
Right. Okay.
Which is semantics, same thing. And even child support, it means the same thing essentially. Yeah, the critical word there is support for.
Right. But I'm speaking about in terms of in our laws, the act itself as well. There is no Child Support Act, right?
Right.
Act speaks of maintenance, and that is the term that is applicable in our legal jurisdiction. So
that is correct.
Right. So can we start with that? Let's start with the definition of child maintenance as it relates to the laws of Trinidad and Tobago.
Well, maintenance is the payment of money to support the child of a family, essentially.
Nice.
Very simple as that. Payment of money.
Simple. Payment of money for the support of a child, right?
Or children.
So it's not just, it does not have to be just one. It can be more than one child, right?
Right.
Right.
Okay. And when we talk about children, we need to understand, generally, we are talking about minors between 0 to 18. However, you may have a child that is older than 18 and maybe mentally or physically challenged and still dependent on his or her parents. You may find in a situation like that, child support can continue beyond 18. Also, you may have a child that is older than 18 and he or she is in full-time school at university or something like that. Maintenance in terms of assistance with education expenses will still be expected depending on the situation. And then thirdly, and this is the one that people don't like to hear about, you may have gotten into a relationship with someone, married someone, and that person had a 2-year-old or 1-year-old, and you accepted that child and you became the custodial father of that child, and that child grew in that relationship over 3, 4, 5, 6, 7, 8 odd years. That child is considered a child of the family. And according to the circumstances, you may still find yourself having to assist when the relationship is over, depending on the circumstances.
Interesting.
So all these are children of the family.
Children of the family. Excellent definition there. Very interesting. So we have identified maintenance as the payment of money in support of a child or the children of a relationship. It is not just children of a marriage. Is it true that both parents legally equally has an obligation? And I think I want to reiterate that for the caring of the children.
That is so abundantly clear that no argument there. And so therefore then, under our laws, this is why like last week we said, no parent has a superior right for custody over the other. And similarly, either parent, because we have single fathers, we know that very well.
Correct.
And they are entitled to seek maintenance through the court from the mother of the child, as well as the mother of a child is entitled to seek maintenance support from the father of a child.
Yes. So we want to make that abundantly clear. Both parents share an equal obligation to maintain the child that they both contributed. Equal obligation, both. So it's not...
that point cannot be overstressed because we live in a society where very often women, and we have single mothers, women are often, and it's not because we are both female, but this is the fact of life, women are often saddled and burdened with the sole responsibility for children when a relationship ends. And we are also acknowledging that the reverse is also true. There are many instances where men, I have that in my practice, where the man alone is shouldering the responsibility.
Yes. I have seen as well that the expectation from the woman sometimes is that the man is supposed to solely shoulder that responsibility. So if the mother has calculated that to maintain the child costs X amount of dollars, sometimes clients don't understand that if it is X, your obligation is X divided by 2.
Not necessarily X divided by 2.
Well, not divided by 2, but part of X. All of X doesn't belong to the father.
Yeah, you are correct about that. But you see, that is the other expectation. Sometimes we think it's X divided by 2. Not necessarily. This is why
it's the circumstances of the parent.
Right. It's not a fly-by-night arrangement. Right. And if this plunges us right into how we go about it. If the person should seek maintenance at the high court level as part of divorce proceedings, you are duty bound to fill out a document for the court that lists all the expenses of the child, and the court helps you. Food, groceries, clothing, uniform, extra lessons, everything concerning the child. The court listed there, and you even have a column that says other. Right. There may be other expenses of the child that is not captured.
Recreational, etc.
Right. And then the court does what we may call a means test. It looks at your means and determine who can pay what.
Right. Now, when I said X divided by 2, I did not mean in terms of the value of X. I meant the responsibility of X. So what I mean by, yes, that's what I was trying to say that, because I do know that the value of what X would come up to be when it is quantified and calculated by the court, those things are taken into consideration. But I wanted to reiterate that even the parent that may have the custodial responsibility, it is not that, well, because I have the child, the other one has to pay for the child. Absolutely. Because you do have some people that go away with that opinion, right?
Right. And in fairness to the custodial parent, remember that custodial parent could be paying a lot in kind.
Right. Sweat equity.
Yes, you're right. Sweat equity, a lot in kind. And generally, in fairness, because I've seen both sides of the coin, the custodial parent puts out so much more.
Right.
And then you have the other side where they feel their money alone is needed.
Enough, yes.
When, as we had said last week, quality time is often more valuable than just sending the money or putting the money in the bank.
Yes, very true. This is such a touchy topic. It's a very social one, as one of our callers, I believe last week, would have highlighted. And so we would have said in our previous part 1 and 2 that these issues, and that's the reason that the family court is not mainly legal and solely legal, but also encompasses so many social parts of this issue. Yeah,
that's correct.
Because it is required. All right, so let's move on quickly to our next question. And these are just coming from the FAQs verbatim of the judiciary's website. We have identified what maintenance is and certain practical application of it. But now we want to ask, who can apply for maintenance? We have identified who is responsible for the maintenance, both children, all parents responsible. But in terms now, who can apply?
We sort of touched on it earlier when we said they're similar to the under custody. Either parent can seek custody. Similarly, either parent can seek maintenance or the guardian of a child.
Yes. What about the residential status of such an applicant?
What do you mean? clarify a little more.
Does the parent or guardian, whether be male or female, are they required to be a resident of Trinidad and Tobago and having control and care of the child?
Well, one, you need to have care and control of the child.
Right.
But I remember having a matter like this,
Mm-hmm.
and one parent was resident in Trinidad, and the other parent was resident in Guyana.
Mm-hmm.
And I remember the judge nicely guided me to the fact that our orders for maintenance, we cannot enforce it externally in another jurisdiction. So I recall from that situation, to my mind, the ideal, if you're seeking maintenance from a spouse, you ought to be in the jurisdiction. Although just about 2 weeks ago, I did a divorce, and one parent was in Trinidad and the other parent is abroad with the child. But the Trinidad parent agreed to put money into a local bank account on behalf of the child who is abroad. So, you see, if parties can agree and realize they have a responsibility, it's a lot easier for the court to assist you in carrying out that responsibility. So the short answer is it has a lot to do with the circumstances, because that parent, she was a mother with the 5-year-old child. She is out there in the USA, but she has many, many ties here, and the father is here. And the father agreed that he's going to put the maintenance money in the Trinidad and Tobago Bank of the mother, and she will access it as she chooses for the maintenance of the child abroad.
Very interesting. Very interesting.
So it can happen.
Yes. And as you said, it depends on the situation and the maturity of the parties involved. But generally, as the judiciary has indicated here clearly, that any parent or guardian, male or female, seeking financial assistance for the child or children in their care and control, in order to apply for a maintenance order, you must be a resident of Trinidad and Tobago. All right, that is the strict application of it. But as we would have indicated, there are circumstances where other things are considered. All right. Now, I have a very interesting.
But go back to that. You are a resident of Trinidad and Tobago, but you could be temporarily abroad.
Correct, yes. But I think the law speaks to actual permanent residents. You know, you are residing there. Yeah, and that's the application. So, which brings me to our next two very important questions again now. We spoke about the maturity of parties and if they can agree, all well and good. Now, if the parties agree on maintenance, do they still have to go to court? If I say I have a 2-year-old and it costs $4,000 or $8,000 to maintain this 2-year-old, and I'm smiling because I am quoting an actual case, right? Yes, and the father says, "Okay, I agree. I am going to give you that $8,000 per month for this 2-year-old." Do you still have to go to court to validate that or to execute that?
The short answer is no, but personally, in my practice, I like, particularly when we come to financial issues, that you have the force of law behind it, so that when one party defaults, you have a remedy built into the order.
Yes.
So yes, parties can agree to many things, but many times parties agree to certain situations just to get the other person off their back. And then I am out of here. You don't see me again. And the person is left holding the rotten end of the stick.
Yes.
Whereas if you have a maintenance order through the court, as we well know, if it is at the magisterial level, you can go back to court after 1 month and have a warrant taken out. And of course, we have this slogan that I don't like, deadbeat fathers. for people who don't pay maintenance and the police have to look for them. And at the high court level, you return to court to have the judgment debtor account, give a reason, and the court can assist you in some kind of maintenance, payment over, it probably vary the period of time or some kind of thing. And then we have an avenue that many persons do not always consider. Once a person is permanently employed in a known institution, you can go for what is called an attachment of earnings, so that the maintenance is taken out at source.
Okay, very interesting. I like that you mentioned that because it brings me to my other point I would like to raise, right? Let's say that's happening. It is attached to my salary, a certain amount is taken out, etc. Mindful that we said that agreement can be made out of court, but for the purpose of having a proper remedy and redress in the event of default, you can have the court get involved, have an order set up. Now, COVID has hit. I used to work for a certain amount of money. It was calculated by the court that this is the X amount that I'm supposed to contribute for my child, but I have lost my job due to COVID, or I have less hours allocated to me. My income has drastically decreased. Can there be a variation of my maintenance order?
All right, let me answer by saying, unfortunately, we've come to a time where every 2 years is COVID. And COVID, poor COVID, bad as COVID is, and I'm standing on the side of COVID for a little moment. COVID is blamed for everything. Everything is COVID. So
very true.
That aside, it is a real situation.
Yes.
And many persons, because of the current world pandemic, have found themselves in financial straits. And many persons are no longer employed one way or the other. So what you do in a situation like that, what persons do, they just sit back. The court says, return to court. Let the court know your situation, and it gives you a chance to prove to the court that you have genuinely tried to alleviate, to improve your situation one way or the other.
Right.
And when the court makes an assessment of your new situation, the court in its wisdom will then decide yay or nay. Then I recall a situation where this man had several comorbidities, is now a very current word. And he returned to the High Court to have the maintenance order discharged.
Right.
And of course, he came with all of his medical documentation, and he was able to show the court what he has already paid when he could have paid. And on the basis
of our listeners, can you clarify what discharged means?
Well, removed, no longer.
Right. Good.
Off the books.
Right.
The order is vacated, no longer. Right? You're no longer bound.
Right.
And because of his very dire situation, the good thing, this is a situation I face, the court allowed my client, would you like to respond? Do you believe that what he has said is true? Have you looked at his medicals? Do you want to contest them as being unfounded or lies or exaggeration?
Right.
But we knew that the gentleman was really very ill.
Yes.
So we agreed to an interim order for him to stop paying maintenance. And then, of course, with time, we accepted that he really could no longer pay. So, but the thing is, the law says there must be a substantial material change in circumstances.
Right. Good.
Yeah, and this is why it's important to come back before the court. So the court makes an assessment as to whether this is so and can vary up or down or completely discharge.
Excellent. So the short answer to that is yes. A maintenance order can be varied or discharged through an application made to the court in whom the maintenance order was made, And as Ms. Joseph would have highlighted, once it is shown by virtue of fresh evidence to the satisfaction of the court that your circumstances has indeed changed, then the application can be granted to either vary the order or discharge it completely. Yeah? So there's provision for it. Which brings me to my final and last question before we open our phone lines and discuss and talk live with our listeners. Last question. This is an interesting one because I saw in the staff chat when the question arose, one of our attorneys responded himself saying he was looking out for this question today in today's segment. The question the question is, if one party remarries or is in another relationship, can they still apply for maintenance?
All right. Remember, today we are talking about maintenance for children. Children's parents do not change. And if a child is a minor and you have an order for the maintenance of that child, even if the mother or the father has moved on in their personal life into another relationship, the maintenance is for the child of that union. So you continue to have a responsibility for the child you fathered or the child you mothered. So because we're talking about maintenance for children. Children's parents do not change.
Why I ask that question is because if members of the public go on the judiciary website, under child maintenance, there is a question like that, and the answer is no. Can I apply for maintenance if I remarried or is in another relationship?
Well, here's what I will not get to.
No, but that question, the reason I'm saying that question does not apply to child maintenance.
Okay, fair.
Yeah, so you need
because
to
I am not. Unfortunately, I am no expert.
Yeah.
Contrary to. And I wish to humbly say I am open to other views.
Right. But what I was asking, because you mentioned about alimony, but is the word alimony used in our local jurisdiction?
I hate to hear it because we import everything from America. Even when we are talking about adults, the word is still maintenance.
Yes. And so that's why
it means the same thing.
That's why I still think there's some confusion because some spouses can apply for maintenance and then you can apply for child maintenance, but there are different types of maintenance. And if we're talking about remarrying and other relationship, that's
spousal relationship. That's correct. So when you remarry, your circumstances have changed drastically.
Yes.
And you really, and law is sensible, although people like to use the A word to describe the law. It's sensible.
Spousal
because you've moved on. You are in a new relationship. Why should your
child hasn't moved on?
That's my point. Parents will always be parents. And you know that. Some of us have grown children in their 30s.
Yes.
And they still come to the mother's pot.
Yes.
They're still children to their parents.
True. Quite quickly, we want to open. Sorry to cut you, but I really want to open our phone lines really quick to see if we could get any callers. Slide in this morning. There was so much you needed to cover and so much we still didn't able to cover. But we still want to encourage you to call us quickly and make your contribution. Can we get the phone lines open?
Oh, yeah, we can do that. Of course, the numbers to call is 342-0081.
Hi, Robert.
Hi, can you hear me?
Yes.
All right, of course. We can open the phone lines now. Guys, you know the numbers to call, 342-0081, 771-1791, and of course, 466-5391.
You said we cannot open the phone line?
Yes, we can. Can you hear me?
Yes, we can hear you.
Yes. So I'm just awaiting the callers to call.
Right.
Yes. Let me give them those numbers again. 342-0081, 771-1791, and 466-5391. Call us and let's talk legal.
Yes, yes. So call us if you have any questions, queries, concern, any comment to make, to contribute to what we were speaking about this morning. You can feel free to do so now. We are taking your calls. Remember, if you're shy to speak to us online, on air, you can also call us after the program, 769-6410. 769-6410 to make your contribution or ask any questions as it relates to family law and child maintenance. All right. Remember, there are provisions to help you in law, but it's important to know the rights that you are given and how it can be made applicable to you in your situation and scenario. So we will wait for any call, and in the meantime, Avian, you were mentioning.
All right. Mm-hmm. All right. I believe we now run out of time. Okay.
Oh boy.
Yes. You know what they say, all good things must come to an end.
Yes, and time flies when you're having fun.
Oh yeah.
Time flies. Okay, so right. I do know that this was a lot that we did cover today. It's a very touchy topic. However, we do apologize for not being able to open the lines adequately. But you can still call us, callers. After now, you can call us 769-6410. Our lines are open. 769-6410. If you have a question in law about this matter, you would like to get some advice, assistance, feel free to do so. Call us 769-6410.
All right.
All right.
Okay, now you guys have a blessed one.
I hope we've been of some use to our callers. Take care.
All right now. All right, guys. So you heard it for yourself. Let's Talk Legal. You would have gotten those numbers to call. All right.